So good morning, everyone, and welcome to today's CenterState CEO webinar, Employment Law Considerations, Vaccines, Paid Leave, and More. This is session 2 of our Return to Work series. Thank you so much for joining us today and your participation. We appreciate it. It's a very timely, very important topic, and I know that you're all here to learn as much as you can. My name is Jessica Underwood. I'm the sales manager at CenterState CEO, and I will also be your moderator for today's webinar. So this webinar, of course, will cover how you can stay informed on the many legal considerations for your business and employees as COVID-19 restrictions and protocols change and vaccinations continue. And we would like to thank Adam Mastrolio from Schoeneck and King for presenting today. Thank you very much. And now, without further ado, I will hand it right over to Adam. Thank you.
Jess, thank you so much. And thank you to CenterState CEO for having me on this morning. It's a pleasure to be here. My name is Adam Mastrolio. I'm an attorney at Schoeneck and King here in Syracuse. I am going to be talking this morning about the 3 most common issues that we're dealing with as it relates to the pandemic at this time. Those issues are vaccination, leave, and workplace safety plans, and how you are going to deal with those workplace safety plans, maybe potentially make some modifications to them based on the most current guidance. So we have a lot to cover. Like Jess said, we're going to try to take some questions after each of the sections. But here are the topics we're going to cover, and rather than waste time talking about them, let's get right into it. All right, so the first topic is vaccination. The most common question we were getting a couple of months ago when the vaccine rollout was first happening is, can employers mandate the COVID-19 vaccine? And what I want to do is walk through how to answer that question. I will unfortunately tell you that there is no 100% certain answer to this question, but there's an analysis that we can go through that will help you as an employer make the decision about whether you want to do that or not. So first of all, let's look at, or we're going to look at the historical context. Is there anything in the history of vaccines that will help us make that decision in this case? We've seen, and we'll cover this in a little more detail in just a second. We'll look at recent EEOC guidance from the Equal Employment Opportunity Commission that's relevant to this question. We're going to consider the emergency use authorization procedure that was used to authorize the currently available vaccines in the United States. We'll also talk about OSHA issues and potential collective bargaining issues as it relates to a vaccine mandate. All right, so we're going to start with historical context. What can we look at in the history of vaccines that will help us answer this question? Can an employer mandate the COVID-19 vaccine? So we know that in the healthcare context, mandatory flu vaccination policies have been permissible. However, we also know that accommodations must be provided absent undue hardship for disabilities, including pregnancy. Pregnancy is not a disability, but it's grouped in with that category, and sincerely held religious beliefs. So historically, the case law, at least in New York and in the Second Circuit, which is where we are, these cases have been unique to the healthcare industry. You've seen nurses or other healthcare providers challenge flu vaccine requirements, and we've seen courts uphold them. There has been very little outside of the healthcare context that would provide us with any information helpful in making this decision in this case. So we do know that recently, last year actually, there was a case in California. It was called Keel et al. Not that that's relevant for you, but you had the University of California college system that implemented a flu vaccine mandate for all students, all employees who were going to be in person on campus. That mandate was challenged on many grounds, and the court in California said, nope, it is narrowly tailored. The requirement is narrowly tailored, and therefore we're going to uphold it. So we now have an additional example of a flu vaccine mandate that was upheld outside of the healthcare context. So we have this historical context where flu vaccine mandates have been upheld. All right, with that historical context in mind, we next look at guidance that we received from the Equal Employment Opportunity Commission in December of last year. So knowing that the vaccine was, I believe the Moderna and Pfizer vaccines were just getting approved in December of last year, the Equal Employment Opportunity Commission came out with some guidance to help employers. Now, the Equal Employment Opportunity Commission, I'm sure as most of you know, is the federal agency that is tasked with enforcing federal anti-discrimination statutes. So there are a number of them. There's Title VII of the Civil Rights Act of 1964 that protects against discrimination on the basis of many protected characteristics, including race, gender, etc. There is also the Age Discrimination in Employment Act, the ADEA, that prohibits discrimination on the basis of age. There's also the Americans with Disabilities Act, the ADA, or the Genetic Information Non-Discrimination Act, GINA. So the EEOC is the federal agency that is tasked with enforcing all of those federal anti-discrimination statutes. Their guidance is very important because it tells us what position the federal government is going to be taking on various issues. There was prior guidance on just general COVID restrictions, etc. But on December 16th, the EEOC issued guidance that was specifically related to employer vaccine mandates. So the first thing the guidance addressed was the Americans with Disabilities Act. And this was important because many employers, lawyers were concerned that having a vaccine mandate would be discriminatory on the basis of somebody's disability. So what the EEOC said was, first of all, the admission of a vaccine is not a medical examination. This was very important because, as I stated in the first bullet there, the ADA restricts an employer's ability to require medical examinations and make disability-related inquiries. So if the vaccine was a medical examination, then there would be significant hurdles that employers would have to jump over in order to make it a mandate. So the EEOC guidance said admission of the vaccine is not a medical examination. That's good. That's good. However, the EEOC went on to say that pre-screening questions may elicit protected information. So, for example, if you as an employer are administering the vaccine and you're asking questions of your employees that elicit protected information, such as disability information, then you may be delving into territory that would be violative of the ADA. And you'd have to go through this analysis where, is the question job related and consistent with business necessity? So that's an inquiry you want to stay away from if you're an employer. You want to avoid that question. So what the EEOC said in its guidance is that you can avoid that question if you can avoid it in two ways. One, you offer the vaccine on a voluntary basis, or if you are having your employees receive the vaccine from a third party with whom you have no contact. So for example, or contract. For example, if you as an employer just said, you have to be vaccinated, we're not going to provide the vaccine. You just have to show us proof of vaccination. That would get you over the job-related and consistent with business necessity issue. So the EEOC guidance told us that one, the shot is not a medical examination, and two, you can avoid questions that would elicit protected information so long as the vaccine is voluntary, or you are mandating the vaccine, but you're not offering it or you're not contracting with somebody to offer it. The EEOC also provided guidance on accommodations. And for those of you, well, you're all employers, I assume, you are all familiar with the accommodation process and employees requesting accommodations. So the EEOC said that employers who are going to mandate the vaccine must provide accommodations to individuals who have either disability or sincerely held religious reasons why they cannot get the vaccine. So with respect to the reasonable accommodation process, it would be your normal accommodation process. I'm sure you all have a process in place whereby you receive accommodation requests, you engage in the interactive process, you determine whether or not there are any accommodations available. If there are, you have to provide the accommodation unless that accommodation would present you with an undue hardship. If there is no accommodation, or if there is an undue hardship, exclusion from the workplace is a potential solution. Now, the guidance makes it very clear that exclusion from the workplace should be a last resort. And I think this is one of the things that we saw from the EEOC in this guidance document. The EEOC doesn't want you firing people because they can't get the vaccine. They want you doing everything you can to accommodate people and to work with them if you are going to have a vaccine mandate. Termination obviously is it's a very last resort and should be done only in the most extreme of circumstances. Certain accommodations are available, and these are the accommodations that we've seen over the last year: remote work, additional PPE, potentially an unpaid leave, which can be an accommodation, additional testing. There are a number of accommodations that I'm sure all of you have looked at within the pandemic, whether or not you have a mandatory vaccination policy. But the EEOC talked about this accommodation process, that you need to provide accommodations to those with disabilities and those with sincerely held religious beliefs. Same thing with the last slide dealt specifically with disability related accommodations. This slide deals with religious accommodation issues. Employers, the EEOC guidance made it very clear that religious accommodations should also be provided. Now, one of the things I wanted to point out is that the guidance, the EEOC guidance, references the fact that these vaccines that were approved, Johnson & Johnson, Moderna, and Pfizer, all were approved using the emergency use authorization procedure. We're going to talk about that in just a minute, but I just want to stay on the EEOC guidance for a second. The EEOC guidance specifically calls it out, says these vaccines were approved using this process. But the EEOC guidance then goes on to talk about employer mandates. So in doing so, the EEOC is implying that employer mandates are okay, but it doesn't come out and explicitly say that they're okay. So that's something to keep in mind as we go through the remainder of the issues. You know, as a lawyer, I wish some governmental authority would just tell us, you can do this. Of course, it's never that easy. And of course, there's never that clear of an answer. So that's why we're having this webinar today. I wouldn't really have anything to talk about if the government just came out and said, you could do this. Unfortunately, they haven't. So here we are. As it relates to religious accommodations, I just want to make a couple of points. First of all, ordinarily, the guidance says that ordinarily, employers should assume that an employee who is requesting an accommodation based on a sincerely held religious belief has a sincerely held religious belief. So you're supposed to go into this assuming that the employee does have a sincerely held religious belief. And the guidance goes on to say that if you're going to question it, you should have an objective basis, either that the employee isn't sincere in their belief or that they don't have an actual religious belief. So I will tell you that courts in our area, in the Second Circuit, take a very broad view of what constitutes a religion. So I'll give you an example. There was a case where an employee said, I need a religious accommodation for something because I'm a member of Onion Head. And who knows what Onion Head is, but the court in that case found that Onion Head satisfied the religion test, quote unquote religion test. And so I provide that ridiculous example to show you that it's hard for an employer to say what you're saying you believe in is not a religion. There's another case involving an organization called the 5 Percenters. again, whatever that is, the court found that that satisfied this religion test. So just be aware of that when your employees are requesting an accommodation. As always, follow your normal process. Document, document, document. Make sure that the request for an accommodation is writing. We've developed forms for clients if they have a mandatory vaccination policy, forms for them to use to provide their employees to request both religious and medical accommodations. Also, if you are going to have a mandatory vaccination policy, I'm jumping ahead here, you need to have a written mandatory vaccination policy. And, again, we've written those for clients, and they're relatively simple, but they need to be in place, and they need to cover the things that you need to have them cover. Okay, so overall takeaways from the EEOC guidance. One, it implies that mandatory vaccination policies are okay, but does not explicitly say so. Two, it recommends that the employers not participate in the vaccinating process. So it essentially says, it implies that if you're going to have a mandatory vaccination policy, you shouldn't be the ones administering the vaccine. So that's something to keep in mind. And the third overall takeaway that I think is important is that the EEOC guidance isn't determinative. In other words, it doesn't answer the question ultimately whether you can have a mandatory vaccination policy. It's one of the pieces of information that we look at and that employers have to look at in making this decision. Okay, so now some issues that are involved with mandatory vaccination policies. The first and the biggest is the fact that these vaccines were approved using the emergency use authorization procedure. This is not FDA approval, as I'm sure everyone knows by now. To receive full FDA approval takes a very long time. So there is a specific federal statute called the Food, Drug, and Cosmetic Act that allows vaccines to be approved temporarily using this emergency use authorization procedure. It doesn't mean that the vaccines haven't been tested. It doesn't mean that they're not safe. It's just a different procedure than full FDA approval. I think that our slides are going to be made available to everybody. Is that right, Jess? Yes? Okay, good.
Yes.
So I've put links right into this presentation. For example, on this page, you'll see a link to the government's website that provides an explanation for you of what the emergency use authorization procedure is and what it means. Now, the issue for employers is that the statute that authorizes this EUA procedure says that the FDA must ensure that recipients of the vaccine under an EUA are informed that they have the option to accept or refuse the vaccine. So this puts employers in a difficult spot. If an employee has the right under a statute to accept or refuse the vaccine, how can I mandate it? We've analyzed this issue and have a couple of thoughts. One, the EEOC guidance certainly implies that there can be vaccine mandates, and it even references the EUA procedure specifically. So that's one thing. Two, an employer could take the position that, yes, you have a medical right to refuse the vaccine. That is your medical right. However, I have the right to have a safe workplace, and what I'm deciding as part of that right is to mandate the vaccine. I will say that neither of those arguments have been tested. So I don't know for sure whether they will be successful, but they are certainly arguments that an employer can make. We've seen the first challenge to a vaccine mandate in New Mexico. There was a case that was recently filed by an employee. He was a corrections officer. Public employees, so the issues are a little different for public employees, but he, in his papers, is arguing that because the vaccine was approved using this EUA procedure, he cannot be required to take it. We don't know how that's going to turn out. We just know that that was the first lawsuit that's been filed, and we're obviously following that carefully. Guidance from New York State, we still don't have any. So, not surprisingly, the state has been releasing a flurry of guidance documents. This has not been one of them. We're still waiting. Maybe it'll come, maybe it won't. Okay, OSHA issues. Now, OSHA has said very little on vaccinations thus far. There was a January 29th guidance document that OSHA put out that recommended the vaccine and encouraged employers to educate or train employees on its efficacy and safety. But OSHA hasn't really gone any farther than that. There is a potential OSHA claim under Section 11C, which prohibits whistleblower protection, retaliation, that you should be aware of. I think it's unlikely, but it's potentially out there. Section 11C protects employees against being retaliated for providing or stating a reasonable belief that the shot could lead to serious illness or death. So the employee says, I'm not taking the shot because I have a reasonable belief that this shot is not safe. Now, that's a stretch, and I don't think it would be successful, but we just want to make you aware of this potential issue. You know, the employee would have to show medically that the shot is not safe, and I think that's getting harder and harder to do as the months go on. Okay, collective bargaining issues. I will say this, if you have a unionized workforce, this adds a very significant wrinkle into a potential mandatory vaccination policy. The NLRA, the National Labor Relations Act, has been interpreted to require bargaining over mandatory vaccinations. Again, that was in the nurse context and the flu vaccine, absent some controlling contract language. So if you have a CBA and you're considering whether or not to implement a mandatory vaccination policy, take a look at your contract. Look in your management's rights clause. Look in your health and safety clause. Is there any language that would authorize you to do this, to put this mandate in place, absent bargaining? If there isn't, you're probably going to have an obligation to bargain, and you're going to have to work with your union and your representation. You also should look at if you have a history of imposing safety rules, flu vaccines, or other medical requirements. Although the contract language is the best course of action, you should also look at past practice. Okay, practical issues with a vaccine mandate. Legal challenges. This is the New Mexico District Court case that I just mentioned. You know, do you want to get sued? Do you want to go through the process of paying me or lawyers like me to defend you in a lawsuit, challenging your vaccine mandate? It's something you have to consider. Potential employer liability issues. If you make this a mandate and someone has an adverse reaction and has to go out of work, does that become a workers' compensation claim? Probably. Again, these are new and novel issues, but the theory certainly is that you've made it a work requirement. Because of the work requirement, somebody gets sick and has an adverse reaction, you potentially have comp liability. Adverse reaction claims are much more unlikely in the employment context, particularly in New York, because workers' compensation would be the sole remedy in theory. So those are some practical issues. Vaccination options, and I apologize if it seems like I'm rushing. We just have a lot to cover here, so I want to make sure to get through it. You as an employer have options as it relates to the vaccine, and they're really on a continuum. And if you think of the continuum, on one end, you have no action. You don't mention it, you don't say anything about it. Employees get vaccinated, great. If they don't, they don't. On the other end of the spectrum, you have a mandatory vaccination policy where you're administering the vaccine. You are saying, employees, you have to get vaccinated and you have to come here and we will administer it. Those are the two ends of the spectrum. Within that continuum, there are other options as well. So for example, you could encourage or incentivize vaccination. You'd still make it voluntary, but you might offer an incentive, and we'll talk about that in a little more detail in just a minute. You could have somebody come in and administer the vaccine on site. Again, still voluntary. You could, if you're going a little more toward the mandatory end of the spectrum, you could mandate proof of the vaccine. So you are mandating the vaccine, but you have nothing to do with administering it. You're just telling your employees, you've got to get vaccinated by such and such a date, and you got to provide me with proof of it. We're seeing a lot of higher education institutions do this. It's been in the news. We've written policies for colleges on this exact issue. But that's a little further along the spectrum. These are just some options to consider. Again, there is no 100% foolproof answer to the question, can we as an employer mandate the vaccine? But I hope that what I've just provided gives you some information and context to make that decision. All right, so here are some FAQs that we've gotten as it relates to vaccines. So first of all, if an employer gets the vaccine, can we relax precautions for those who are vaccinated? Now we're going to talk about the new guidance that just came out last week in a little bit, the mask and social distancing guidance. But the bullet number one here is follow state rules. So if your state says, in New York in particular, if the state says we can relax certain precautions, then that's okay, but that doesn't mean you have to. So that's the answer to that question is maybe. Look at what your state rules say, look at what New York says, and make a decision if that works for you. It might not. You may say, or you may make the decision that you don't want to relax your precautions yet. That's absolutely fine. CDC guidance. New York has been adopting the CDC guidance since around December, when the CDC has come out with something. New York has, within a week or two, generally adopted, with some tweaks here and there, what the CDC is saying. Okay, proof of receipt. Can an employer require an employee to show proof of their receipt of the COVID-19 vaccine? And again, I think we know now the answer is yes. The EEOC guidance that we discussed from December actually answers this question and says that that is not a disability-related inquiry, so it's okay. However, don't go further. So if you are going to request proof of vaccination from your employee, stop there. Don't ask any follow-up questions, because those follow-up questions could elicit protected information, which you don't want to do. A little tip here is that if you are going to ask, it might make sense to inform your employees that you don't want any additional information. You just want to know yes or no, are you vaccinated? All right, vaccine incentives. What incentives are permissible? We've answered this question quite a bit. So vaccine incentives are generally considered to be wellness programs. As such, they're subject to certain limitations under federal laws, including the ADA and GINA, which are two statutes we talked about. As it relates to the ADA and GINA, you can avoid those issues if you're not the one administering the vaccine and you're not contracting to administer the vaccine. So the ADA and GINA have amount limits on how much you can offer as an incentive, a wellness program incentive. You have to follow other ADA requirements, however, such as accommodations. So if you have somebody, you're offering, let's say you're offering a $50 or $25 gift card for those who are vaccinated, and somebody comes to you and says, I can't get vaccinated because I have a disability or I have a sincerely held religious belief, then you have to make sure that you have alternatives for them. And that's something to keep in mind if you're going to put a vaccination incentive program in place. HIPAA is also implicated. HIPAA has a non-discrimination provision that limits your ability to provide or offer these incentives. There have to be restrictions on availability, frequency, reasonable design, and notice of availability. In other words, employees have to be notified that these programs or this program is available and how to achieve it, how to get it. All right, so now we move on to another FAQ. What about employees who cannot get vaccinated? So if an employee can't get vaccinated, you go through your accommodation process, as we talked about. Get the accommodation request in writing, go through the interactive process, document what you're doing in the interactive process, document the steps, document the outcome. Provide the accommodation unless there's an undue hardship, and make sure it's clear what you're doing and why, and all of that is written. Okay, so Jess, I don't know if you want to ask me some questions or if you want me to move on to leave issues.
Well, so far you've answered everyone's questions. I believe there are no additional questions right now, so you can move right on.
So are you telling me, Jess, that there were questions, but that I answered them, or that there were no questions?
Well, I can't say that. I don't know. I think you did a great job of explaining things.
Fair enough. Okay. So let's move on to topic number 2. which is COVID leave issues. I want to start this section by just talking about employee leave requests generally, because I think something that happened at the beginning of the pandemic is employers didn't necessarily forget, but you just abandoned your normal employee leave request process. And I would encourage you not to do that. So whenever you receive an employee leave request, start with, okay, well, what are my policies that I have in place? What's my PTO or sick leave policy? Do I have a remote work policy? I know a lot of employers did not have remote work policies in place. And then the pandemic hit and they're flooded with remote work requests, or remote work becomes mandatory because the governor shuts everything down. So what is your telework policy? What is your attendance policy? Do you have a leave of absence policy that's in place? You know, what does your collective bargaining agreement say about leave? These are very important things to think about whenever you get a leave request, whether it's COVID related or not. So start there. After you get employee, you look at your existing policies, think about the existing statutes that you all know about and that you've been dealing with for years. So the FMLA, the ADA, discriminations, anti-discrimination statutes like the New York Human Rights Law, or the other federal statutes that we talked about. You know, how is comp implicated here? Is there any disability law that's implicated? And now in January, we had to start dealing with New York's paid sick leave law, which I'm sure you all are aware of. So you look at, okay, what are my existing policies? What are the existing leave laws say that I have to do? And then the third step in the analysis, which is what I'm going to focus on during this presentation, is what are the COVID leave laws? Because both the federal and state governments enacted leave laws that were specific to COVID. And they enacted these laws quickly, and they enacted them without answering many of the questions that employers had. So what I want to do is just walk through what was available, what is currently available, what laws you have to consider and should consider in the COVID context. So first of all, let's start with the Families First Coronavirus Response Act. The FFCRA, as everyone I'm sure knows, provided two types of leave. It provided emergency paid sick leave and emergency expanded family medical leave leave. So with respect to emergency paid sick leave, that was 80 hours offered by the employer. There were 6 qualifying categories that would entitle an employee to leave, to EPSL leave. Employees would be paid for up to 80 hours at their regular rate of pay, either full regular rate of pay for the first 3 categories, or 2/3 of their rate of pay for the second 3 categories. The first 3 categories dealt with that employee's own health status. The second 3 dealt with the employee helping others or others who were in their care. The EFMLA covered 10 weeks or provided 10 weeks of pay at 2/3 pay for employees whose childcare was gone or their school was gone. They needed to take care of their children at home. So it was limited, but it was also mandatory. And it was mandatory from when it was first enacted last year through December 31st of 2020. So at the end of December 2020, the mandatory FFCRA leave went away. However, there was a statute that was passed by Congress in December that extended the credits available for employers to offer FFCRA leave through the end of March. And then when the American Rescue Plan Act was passed, those credits were voluntarily extended through the end of September of this year. So we'll talk about the ARPA in a little more detail in just a moment. I just want to give you a look at the landscape of what's out there. So in addition to the ARPA, we currently have New York's COVID leave law, which was put in place last year, which provides sick leave for individuals that we'll talk about. We also have New York's COVID vaccination leave law, which was just passed, which I'll talk about in a little more detail. But these are the statutes, the COVID specific statutes that we're gonna discuss. Okay, so let's start with New York's COVID leave law. New York's COVID leave law applied to public and private employers, and it said that employers had to provide up to 14 days of paid leave, depending on size. So New York's law broke it down by number of employees and amount of revenue. And the amount of leave would either be nothing, all the way up to 14 days of paid leave. A number of sizes in between, employers had to provide paid 5 days. The most employers had to provide was 14 based on the number of employees. What New York did was they said that employees who were subject to a mandatory or precautionary order of quarantine issued by New York, the Department of Health, or any governmental authority authorized to issue that quarantine order, they would be entitled to this leave. In that way, it was much more limited. New York's law was much more limited than the FFCRA, which had these 6 very broad categories. You only were entitled to New York leave, COVID leave, if you had a quarantine order that applied to you. So we saw this early on where we'd have parents who are employees and they'd say, my son got a quarantine order, I'd like my New York COVID leave. Well, that's not what New York COVID leave is for. New York COVID leave is only if you have a quarantine order. Now, many times parents would get quarantine orders because the local county health authorities would say, you've been a close contact, therefore we're going to put you in quarantine. But in order to receive New York's COVID leave, you, the employee, had to receive a quarantine order, had to have a quarantine order. The New York COVID leave law provided job protection. So employers could not discriminate against employees who received this leave, excuse me. It also, the law stated that this leave could not be charged against other leave, including sick leave, which is important. I mean, you're essentially as employers being asked to provide an additional 14 days of unpaid leave, or of paid leave. And the government was just telling you to do it. Unlike the federal law, the state law didn't provide you with any tax credits for doing this. It just said you had to do it, which stinks for employers, but that's what the law said. The amount of leave is the amount the worker would have otherwise received during the period. So for example, if you had a part-time employee, that employee wouldn't get 14 days of full-time wages. They would get the amount that they would typically have received in that 14-day period. And you'd have to make a calculation looking back generally 6 months, according to the guidance that the state put out. You'd look back for part-time employees for 6 months, see how much they typically worked in a 2-week period to determine the amount of leave that was available. One thing I would note is that this law is still in place. And so if you have employees who are subject to a quarantine order, you have to provide them with this New York COVID leave law, or COVID leave. We've had employers ask in the last couple of days, last weeks, since the vaccine has been more prominent, why do I have to pay my employee who just refused to get a vaccine when they catch COVID? And the answer is that, I hear you, I sympathize with you, but if your employee is subject to a quarantine order, then you have to provide them with the New York COVID leave. Okay, the next COVID leave law that I want to cover is New York's COVID vaccination leave law. So this is a law that was passed in the last couple of months that specifically deals with time spent by employees getting the COVID vaccine. It applies again to public and private employers, and it says that employers must provide a sufficient period of time, up to 4 hours per injection. So some employees were going to their employers early on after this law was passed and saying, okay, I want my 4 hours to go get the vaccine. And employers, you could say, no, you get up to 4 hours. You schedule your appointment, tell us when the appointment is, go to the appointment and come back when you're done. You don't get a free 4 hours. In other words, this isn't just, oh, I get 4 hours. You get a sufficient period of time up to 4 hours. So that was something that we heard very early on after this law was passed. Again, this cannot be charged against other leave, including sick leave. It is likewise paid at the employee's regular rate of pay. It also prohibits discrimination for requesting a vaccination leave or otherwise exercising rights under the law. And it's effective March 12th, and expires automatically on December 31st. So this is another COVID leave law that you all should be aware of. Let's move on to the American Rescue Plan Act. So this was the law that was passed by Congress and signed by President Biden earlier this year. It is an extension, or it provides, among other things, an extension of the tax credits for paid leave. So I have at the bottom here that it's voluntary. I should put that up at the top because that's really the most important thing. It is voluntary. You as employers do not have to continue to offer the FFCRA leave if you don't want to. However, if you want to get the tax credits, you can continue to offer both EFMLA and EPSL. The American Rescue Plan Act also increased the categories that an employee could qualify for leave under. So for example, it now allows paid leave for an employee getting a vaccine, or for an employee recovering from complications due to receiving the vaccine, or for an employee seeking or awaiting the results of a COVID test or diagnosis if the employee has been exposed or the employer has requested such a test. So if you are an employer and you want to continue to offer the FFCRA leave, you can do so, but there are these additional categories. It also resets the 80 hours of EPSL. So if your employee had used some of that on April 1, that 80 hours would be reset. It also increases the EFMLA eligibility to include all the categories that we saw before, all the categories that were available for EPSL. If you remember, under the old FFCRA, EFMLA leave was limited only to employees whose childcare was unavailable. With the ARPA, that's now expanded to all of the categories that are available for EPSL. And again, I apologize for using all these acronyms. They get tiring, but it's the most convenient way to talk about them. The ARPA also disqualifies employers from the tax credit where they differentiate between how they treat different employees. Okay, so here are some frequently asked questions as they relate to these particular types of leave. Do I have to provide paid leave for an employee to get vaccinated? I think the answer to that question is pretty clear. It is yes. Is the paid leave retroactive? And I think the answer to that is also clear, and that's no. The obligation arises on the date that the statute went into effect. Neither statute talks about retroactive application. Do I have to notify my employees of the right to this paid time off? So if you remember, under the FFCRA, there were some posting requirements that you had to make sure employees were aware of their rights under the FFCRA. There is no similar notification requirement under the state vaccination leave law. Okay, does the vaccination paid leave apply to part-time employees? Yes, the statute says it applies to employees. So that's part-time or full-time. Does the ARPA vaccination leave run concurrently with New York's paid vaccination leave? This is a bit of a technical question, but it's one that we got quite a bit. And this is for employers who wanted to get the credit, obviously. So the theory or the thinking is, if it's mandated, if I have to pay employees for this vaccination leave under New York law, then can I also take the credit under the ARPA? And our analysis of this, while not settled, is that yes, you start with the baseline of, do you have to provide the paid leave? Yes. For vaccination, yes. If an employee goes to do it and you are offering EPSL voluntarily, you should be able to get the benefit of that credit. So yes, that they would run concurrently. You only get 2 shots. You only get the leave associated with getting those 2 shots, and you should be able to get the tax credit. Okay, can I claim the tax credit if I only provide EPSL but not EFMLA? A lot of employers were asking us this question as well. And I think that the way that the ARPA is written helps us to answer this question. The ARPA has 2 separate sections, one on emergency paid sick leave, EPSL, and one on EFMLA. They are separated. Each section contains a statement that if the employer fails to provide one kind of leave under this provision, then they don't get the tax credit. But they're separate. So our interpretation of that has been that if you can provide only EPSL, you have to provide all the EPSL credit categories, but you can provide only EPSL and get the credit for that, or you can provide only EFMLA and get the credit for that. But you don't have to offer both. So that's our interpretation. Again, it's not settled, but that's how we've been reading it. Can I claim the tax credit if I only provide paid leave for vaccination, but not any other EPSL qualifying event? The answer to that would be no, because the EPSL section says you have to offer all the categories of EPSL in order to get the tax credit. So those are a couple of technical questions, but we received them enough that I thought it would be worth it. Okay, any questions, Jess?
Looks like we've got one.
Okay.
So what if an employee becomes sick from the vaccine and needs to be out of work? Does that fall under regular sick time or possibly PFL?
So let's start with, if you are offering ARPA leave, you voluntarily decided to continue, then it would fall under the FFCRA leave, the ARPA leave. All right, so that's step one. Are you voluntarily continuing that leave to get the tax credit? If you are, one of the EPSL categories is complications due to getting the vaccine. So that's step one. Okay, if you're not offering or voluntarily continuing FFCRA leave, then, you know, if an employee's out, then they would have to use their sick time. I mean, there's no statutory requirement to provide leave for sickness associated with the vaccine. There is a complicating issue, however, if you're mandating a vaccine and somebody gets sick, then does that become a workers' compensation claim? I don't know. That hasn't been tested, but I would say that if you're not mandating it, somebody gets sick after they get the vaccine, then they'd have to use their sick time or other available PTO. Last topic, and I will be quick here. Workplace safety plans. So everybody over the last year, most likely last June, July, and August, were putting together workplace safety plans. Depending on the phase in which you were a part of, phase 1, 2, 3, or 4, as you're reopening, you had to put together a reopening plan. I know that CenterState CEO has a great resource on reopening plans, and I was jealous of it when they put it out last year because it included so much good information. But we know that there are common elements to these plans. They all had to discuss social distancing, PPE, hygiene and cleaning, communication, screening, infection exposure response, including return to work. So whatever your policies were, all plans had to include these elements. Now, there have been some recent updates that might cause you to take a look at your plans and think about how you're going to change them, if at all. So first of all, this guidance that came out last week, the guidance everyone's talking about, which is the mask and social distancing guidance. Again, I've linked to it here in the presentation. This guidance said that fully vaccinated individuals don't need to wear masks or social distance in most instances. It does state that masks and social distancing are required for certain employers or certain settings like healthcare, schools, public transit, etc. The guidance specifically says that businesses may continue to require masks for all individuals. Now, the guidance gets a little squirrely here and deviates from the CDC in that it says that if you are a business that's not a place of congregation, or you have fewer than 250 people indoor, 500 outdoor, you can request proof of vaccination in one of two ways. You can either check through paper, digital, or Excelsior Pass, or you can use the honor system. It's up to you. So if you're a business and you are small enough to meet those criteria, you can operate under the honor system if you want. That might make you want to change how you what's in your workplace safety plan. So I know here at Bond, we just changed our workplace safety plan on Monday. We're requiring proof for individuals who are vaccinated, but if that proof is provided, then there is no mask or social distancing requirement anymore. So it's a big change. Another potential change is in the return to work setting. So first of all, generally, you have this May 31st of last year, this guidance that came out return to work following infection or exposure in certain circumstances where you have a positive test, close contact with symptoms, close contact without symptoms, or symptoms without close contact. That guidance has been solid and remains solid, but there have been additional guidance documents that might modify it. So for example, there is new guidance from the state, which is linked here, that addresses quarantine for individuals who are exposed to COVID-19. So for those who are fully vaccinated, you don't have to quarantine following close contact with someone who's positive anymore, so long as you're asymptomatic and you are quote unquote fully vaccinated. So you're more than 2 weeks beyond the last dose in your series. So that might cause you to look at your policy, make a change. Additionally, that same guidance says that you don't have to quarantine if you've had COVID in the last 90 days and you've recovered and you're asymptomatic. So again, that's something you might want to take a look at your plan and make a change. There have also been a lot of changes to the travel guidance. Most recently, the April 10 document, which I've linked here, takes away the requirement for any quarantine following domestic or international travel. So all of the nonsense that you all went through last year, trying to figure out whether a state was on a particular list, and then trying to figure out whether a state was contiguous or whether the employee traveled for more than 24 hours, all that's gone. You don't have to do that anymore. There are no longer any travel quarantine or furlough requirements for domestic or international travel. So that's a big change that came out on April 10th, which caused a lot of, well, it relieved a lot of employers who were dealing with these issues. International travelers doesn't require, there's no quarantine required. There are a couple of exceptions which are noted there. HCPs are healthcare providers. So screening questionnaire and temperature checks. We've had this question a lot. Do I still have to do my daily questionnaire? Yes, you do. The state has not changed that requirement. However, you should evaluate your screening questions. The three mainstays, so to speak, are you symptomatic? Have you had close contact? Have you had a positive test in the last 14 days? Those certainly still have to be asked. However, if you were still asking about travel, you might want to take that out because it's no longer necessary. And this question, are you going to ask about vaccination status? That's something you can do as an employer, but is it something you want to do? So that's something you want to think about. Now, lastly, the elephant in the room is the New York HERO Act. And this was a law that was just passed by the New York State Legislature and signed by Governor Cuomo. It requires businesses to adopt airborne infectious disease prevention policies. It excludes public employers. However, every business is going to have one of these plans in place. The statute says that the Department of Labor is supposed to promulgate minimum standards and these model prevention policies based upon industry. We don't know what they're going to look like. Presumably, they're going to follow the template that the state was providing last year for workplace safety plans, but we just don't know yet because the Department of Labor has not produced these templates yet. The governor also said that he was signing the bill with the understanding that there would be quote unquote technical changes that would be coming shortly. We're still waiting for those technical changes. So as I discuss workplace safety plans, I do so with the caveat that the New York HERO Act is going to provide, or the Department of Labor under the New York HERO Act is going to provide these template plans for employers. And that may drastically change what you have in your workplace safety plan. We just don't know yet.
Thank you. That was fantastic. I believe you intuitively knew all of their questions and and just answered them, which is extremely helpful. Thank you.
Well, thank you very much. It was a pleasure to be here. If anybody has any questions, feel free to reach out. I'm happy to answer them. And thank you again.
Fantastic. Thank you. We really appreciate it. Have a great day, everyone. Please visit our events page, upcoming events coming up, and look forward to seeing you at the next one. Bye.